greetings to one and all present here. It's been after long that we are meeting on this platform for one more interesting lecture. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be enlightening you all on the topic Separation of Powers. Let's begin with an introduction. India is a federal democratic country where the doctrine of separation of powers is followed for its efficient administration. According to the doctrine of separation of powers, the powers of state are divided into three different organs such as legislature, executive and judiciary. These three organs help to enact laws, implement laws and check the validity of laws. Each branch works independently in its own sphere with proper demarcation of its works, which provide exclusiveness to the functionality of each organ. Because of the doctrine of separation of powers, each branch prohibits to interfere in the working of the other branch. Because of the fact that one organ will be checked by the other organ, doctrine of separation of powers reduces the chance of misuse of power, corruption and helps to reduce the chance of enacting a tyrannical law. The doctrine of separation of powers is followed in India, but not in the strict sense as of the other countries like America. In Indian Constitution, the principle of separation of powers is not presently expressly, but it is impliedly introduced in its provisions in the form of proper division of authorities, functions of three organs and a system of checks and balances generally followed within it. Now, what is the meaning and different definitions of this doctrine? The aim of the doctrine of separation of powers is to keep check on the powers of different organs of the government. This doctrine also helps to prevent concentration of power in one hand and also to prevent it from becoming too powerful or infringing on the rights of citizens. The doctrine of separation of power is based on the idea of prevention of tyranny, protection of individual rights, transparency and of course the accountability. As very well stated by Lord Acton, power corrupts and absolute power tends to corrupt absolutely. In separation of powers, the responsibilities, authorities and powers are divided between different organs rather than being centralized in one organ. According to Blackstone, wherever the right of making and enforcing the law is vested in the same man or in the same body of men, there can be no liberty. According to Wade and Phillips, the doctrine of separation of power implies, number one, that one branch of government should not carry out the duties of another, such as giving ministers legislative authority. Number two, that one branch of the government should not exert control over or interfere with another branch's performance of duties, such as when judiciary is separate from the executive branch or when ministers are not answerable to the parliament. Third, that the same individuals should not serve in more than one of these branches of the government, such as sitting as minister in the parliament. Madison, the Federalist of USA, observed that the accumulation of all powers, legislative, executive and judicial, in the same hands, whether of one or a few or many, and whether hereditary, self-appointed or elective, may justly be pronounced the very definition of tyranny. According to Markham Mont Needham, separation of powers requires separation of legislative and executive powers into different hands and persons. According to Richard Benwell and Onagh Gay, separation of powers refers to the idea that the major institutions of the state should be functionally independent and that no individual should have powers that spans these offices. Another renowned professor, that is Professor Lasky. It is necessary to have separation of functions which need not to imply a separation of personnel. The doctrine of separation of powers is connected to the word trias politica, which means tripartite system, which is based on the idea that the powers of the three different organs of the government should be delegate and distribute according to their defined jurisdictions. So, the doctrine of separation of powers creates distinction in the functioning of three organs, but a system of checks and balances should also be there. This doctrine of separation of powers represents two different aspects. One is positive and the other one is negative. In its positive sense, it means integrity and independence of each branch. And in the negative sense, it denotes non-encroachment in the jurisdiction of each other. Now, when we are talking about separation of powers, we have to discuss Montesquieu's theory. The origin of this principle can be linked back to the period of Plato, Locke and Aristotle, who had for the first time classified the functions of the government into a set of three different categories. Number 1, deliberative, magisterial and judicial. Number 2, continuous executive power, discontinuous legislative power and federative power. A French jurist, Montesquieu, is known as a modern exponent of doctrine of separation of powers. For the first time, this doctrine of separation of powers was introduced by Montesquieu in his book that is named as El Spirit Dios Lois, means Spirit of Laws, which was published in the year 1748. Montesquieu signifies that legislature, executive and judiciary should exercise their powers independently and there should not be concentration of power in one hand as a person or a body. It means each organ should work in its own sphere and refrain from interfering in the jurisdiction of other organs. In the view of Montesquieu in his book, when the legislative and executive powers are united in the same person or in the same body or magistrate, there can be no liberty. Again, there is no liberty if the judicial power is not separated from the legislative and the executive power. Where it joined with the legislative power, the life and liberty of the subject would be exposed to arbitrary control, and for the judge would be then the legislator. Where it joined with the executive power, the judge might behave with violence and oppression. There would be end of everything was the same man or the same body to exercise these three powers. Montesquieu focused on the supremacy in political liberty and stressed upon the idea that to prevent abuse of power, the system of checks and balances has to be added in the state. He described that there should be link between political liberty, separation of powers and the system of checks and balances in a particular state. Now, let us come over to the constitutional provisions. As per the Indian Constitution, there are three organs of the government, that is legislative, executive and judiciary. Legislature as an organ deals with the functions of Parliament, Lok Sabha and Rajya Sabha and the state legislative bodies. Executive related to the governments at the union and the state level. Also, the judiciary mainly consists of the Supreme Court, High Court and all the other subordinate courts. They mainly deal with the lawmaking, implementing the laws and of course, the interpretation of the laws. According to Article 50 of the Indian Constitution, the state must separate the judiciary from the executive branch of the government in public services. But in fact, the Article 50 of the Constitution of India is a directive principle and therefore it is not enforceable. In Indian Constitution, the basic structure theory preserves the doctrine of separation of powers. Under this basic structure theory, if functions of the three organs are the part of the basic structure, then that functions cannot be interfered by others, even not with the amendment. Article 121 and Article 211 of the Indian Constitution ensures the non-encroachment of legislatures in the judicial conduct of the judges of the Supreme Court and of the High Court. Under Article 122 and 212, no court can question the validity of the proceedings in the Parliament. Another, under Article 361, the President of India or the Governor of the state is not answerable to any court for the exercise and performance of their duties in their offices. But sometimes there is overlapping of powers. Now, what is that? The legislature is the primary law-making body and judiciary may declare a law made by it as unconstitutional by judicial review under Article 13 and further may give suggestions and advice to the legislature about the framing of new laws and amendment of the laws, but it cannot overtake the function of legislature. On the other hand, executive and legislature works collectively under Article 111 of the Constitution regarding the consent of the President and Governor while finalizing the union and state level legislative bills. Under Article 75, Clause 3 of the Constitution, the Council of Ministers are collectively responsible to Lok Sabha. In Indian Constitution, the President of India appoints the Council of Ministers on the aid and advice of Prime Minister, and the Council of Ministers hold their office during the pleasure of President under Article 75. The members of the Council of Ministers are selected from the members of the Parliament, which are responsible to aid and advise the President. Another provision is under Article 123 and 213. The President at the union level and the Governor at the state level can also enact ordinances under certain specific circumstances, which is direct interference in the working of legislature at the union as well as at the state level. Article 54 makes the legislative branch responsible for election of President of India, as the President of India is elected by the Electoral College, which include members of both houses of Parliament and the legislative assemblies of the states. Another instance is under Article 61, the impeachment process of the President of India that can be initiated by either house of the Parliament for violating the provisions of the Constitution. The Vice President of India serves as an ex officio chairman of the Rajya Sabha. The Vice President of India is elected by the members of Parliament, that is by the members of Rajya Sabha and the members of Lok Sabha. Again, another provision is Article 67. Under that, he can be removed from office by a resolution passed by a simple majority in the Rajya Sabha with the approval of the Lok Sabha. Supreme Court of India can investigate and resolve the disputes related to the election of President of India under Article 71. The Parliament has the authority to amend the Constitution under Article 368 subject to some special majority requirement. Another instance under Article 124, the Parliament of India has the power to fix the number of judges of the Supreme Court of India. The appointment and resignation process of the judges of the Supreme Court of India is also going through the office of President of India. Under Article 142, the Supreme Court has been given the powers to do complete justice in any case where the laws are found to be inadequate for the grant of relief. Another provision, Article 125. The Parliament decides about the salaries, privileges and other allowances of the judges of the Supreme Court. Under Article 32 and Article 226, the writs can be filed against the other organs. Under Article 323B, which gives the power to the Parliament and the state legislature to set up tribunals to adjudicate the disputes relating to taxation, industry, labour, rent, tenancy, land reforms and many more. As a parliamentary form of government, India accepts the interconnectivity of the three organs, which means it does not follow the absolute separation. But here, it cannot be said that it is not a separate in India. Subject to checks and balances, the doctrine of separation of powers has been accepted to a certain extent in India. Now, what is the importance of this doctrine? The doctrine of separation of powers is important because, number one, it provides a vital system of checks and balances in which different branches control each other by making themselves accountable to each other in the form of checks. Number two, to ensure that no individual or group of people in the government is all powerful. It divides the power between the three different organs of the government. Number three, the doctrine of separation of powers prevents the abuse of power. Number four, it ensures transparency by making all the three organs liable, accountable as well as answerable to its citizens for its actions. Number five, it protects the democratic nature of the government under the shadow of basic structure theory by eliminating other forms of government. And last, number six, it helps to make the laws as just, fair and of course adhere to natural justice. Now, what are the pros? What are the merits of separation of powers? The separation of powers has many merits, including, firstly, it creates a system of checks and balances in which each branch of the government can check the others to prevent any one branch from becoming too powerful or abusing their power. Number two, it protects the citizens from oppression and despotism. Number three, it protects the liberties and rights of individuals. Number four, it helps to ensure that each branch of government performs its functions within its prescribed jurisdiction that further promotes order in smooth administration and governance. Number five, it increases the working efficiency of the organs by distributing the powers among them. Number six, it prevents autocracy and helps to maintain a democratic structure of the government. Number seven, it is based on the rule of fairness by directing that every part of the state to follow the rules. Number eight, it is a basic component of majority rule governance in the modern world. 9. It reduces the chances of arbitrary action by the government. Number 10. It helps to enhance government accountability. And last one, it encourages the specialization of each branch of the government in its particular function, which helps to create more effective and efficient governance. Now, apart from the merits, there are some demerits of separation of powers. There are demerits of this doctrine, as Professor Garner has rightly said. The doctrine is impracticable as working principle of the government. According to Frank Further, enforcement of a rigid conception of separation of powers would make the government impossible. So, the demerits are as follows. Firstly, the clashes of the branches over jurisdiction or authority can lead it to gridlock or inefficiency. Next, the conflict and the confusion can be caused by overlaps between the branches, which can directly undermine their effective governance. Next, generally, the branches of the government are controlled by the people of different political parties having conflicting ideas. In this case, it becomes very difficult to enact policies or create new laws which lead to governmental inaction. Next, if there is non-coordination between the organs, the government operations can be affected with complexity and inefficiency. Another demerit, sometimes delays due to challenging nature of coordinating activities and policies across the organs can lead to inconsistent or contradictory policies. Another disadvantage, in the time of crisis, there is a need of rapid decisive actions, but due to separation of powers, it can slow down the process. The delay in the collective approval or consent across the organs can adversely affect the response to emergencies and can exacerbate the situations. Another demerit, it can cause power imbalance because of the concentration of power in one organ. One organ can overstep its jurisdiction without proper checks from the other organs. Next, non-centralization of the system of the government can be very costly because different organs need separate bureaucracy and infrastructure. And last but not the least, because of this separation of powers is very cost effective, it can raise the taxes and can also reduce the funds for public services. Now, let's talk over the important case laws on this. The judicial view on the doctrine of separation of powers is divided between its extent and limit. Majority of the judges of the Supreme Court recognized the concept of doctrine of separation of powers, but they have also inclined towards the system of checks and balances. So, here are some important cases. First is reference Delhi Laws case of 1951. The Supreme Court recognized the concept of delegation of powers by declaring it inevitable, as in the presence of concept of separation of powers, one comprehensive all-inclusive legislation cannot be formulated by the legislature. In another case, that is of Rai Sahib Ramjawaya versus the state of Punjab of the year 1955. The Supreme Court held that due to complexity of the nature of work of each organ, sometimes overlap is bound to arise as there is no strict separation of powers provided by the Constitution. So, to follow the concept of social welfare, the executive needs to be backed by the proper legislation. Another very landmark case of 1967 is I.C. Golaknath versus State of Punjab, wherein the Supreme Court held that the doctrine of separation of powers has not been accepted in a rigid sense in India. There is a personal overlapping along with the functional overlapping. Another case of Ram Krishna Dalmia versus Justice Tendulkar of 1958, the Chief Justice S.R. Das has given opinion that Indian Constitution does not have express and direct provisions for the strict separation of powers. In Jayanti Lal Amrit Lal versus S.M. Ram case of 1964, the Supreme Court once again recognized that Indian Constitution has an implicit division of powers. Now comes the landmark case of the constitutional history, that is Keshavananda Bharati case of 1973, wherein the Supreme Court held that the Parliament's amending power is subject to Constitution's basic features. So the role of legislation is restricted to the check of judiciary. In the Indira Nehru Gandhi versus Raj Narain case, 1975, Justice Chandrachud expressed his view that the political purpose of the doctrine of separation of powers is not widely recognized. No provision can be properly implemented without a check and balance system. This is the principle of restraining which has its percept innate in the prudence of self-preservation, that discretion is better than its valor. Another case of 1998, that is Swaran Singh case. By declaring that Uttar Pradesh's governor pardon of a convict as unconstitutional, the Supreme Court has negated the theory of separation of powers. Another case of Rambhaj and others versus State of HP and another, the Supreme Court held that the judiciary as an organ should not interfere in the area reserved for the legislative organ. 2007 case, that is Divisional Manager Aravali Golf Club versus Chandarhas, wherein the court held that one organ of the government should not interfere into the domain of other. Another case is University of Kerala versus Council of Principals Colleges Kerala. In the year 2010, Justice A.K. Ganguly very rightly said that doctrine of separation of powers uphold the individual liberty and the rule of law, as the power concentration in one authority would promote tyranny. Very latest case of 2023, that is the Ashwini Kumar versus Union of India. The Supreme Court expressed the view that the doctrine of separation of powers is a part of the Indian parliamentary democracy. There, the executive and the legislative linked in relation to their powers and functions. That's about the case laws. Now let's conclude the topic. In a contemporary democratic society, the doctrine of separation of power is working in a broader scheme of division of organs. In depth of the organs functioning, the interconnection of these is apparent in India. In our country, the principle of separation of powers cannot be applied strictly because of the fact that with complete separation of powers, a government cannot work effectively. The concept of delegation of powers, judicial review, principle of harmonious construction of laws, and number of constitutional provisions accepted the mutual connection of these three organs. But it does not mean that the principle has no relevance nowadays. As was rightly remarked by Montesquieu, the doctrine of separation of powers should be exercise its power on the principle of checks and balances, while signifying the fact that no organ of the government should transfer its essential functions, which are a part of the basic structure, to the other organ. Thank you everyone for your valuable time and attention. I also appreciate the opportunity to speak and share my views with you today. Thanks once again. Take care. God bless you all.